Good morning, everyone, and welcome to today's webinar, Repositioning Your TCPA Strategies in a Post-ACA World, hosted by Contact Center Compliance, 5.9, and the TCPA Defense Force at Innovista Law, with a special guest appearance from Christine Riley at Manat. Some quick housekeeping issues before we begin. We have the question box on the right-hand side of the webinar console. Please submit your questions there. Contact Center Compliance will follow up via email with a recording of the webinar and a copy of the presentation. And if you need more TCPA guidance, you can join us, Contact Center Compliance, Innovista Law, and Christine Riley at our next TCPA Compliance Summit in Chicago, this July 9th and 10th. So, quick disclaimer, we have to provide the obligatory disclaimer. The content you're hearing is intended to be informational rather than legal advice. This stuff is really complex, and we definitely recommend consulting an attorney. So, quick update to our speaker lineup. Joe Bowser was called away today to court, so we have his colleague from Innovista Law, John Nelson, here today. John has been with the firm since the formation of the TCPA Defense Force. We also have Ryan Thurman, who has lived, slept, and breathed TCPA and DNC compliance for 15 years. He actually dives into this material at the statute level and case level, so if you have any questions, I'd love to see somebody stump him. Next, we have the product guy from 5.9, Daryl Addington, who directs their product marketing efforts. Daryl has over 20 years of contact center experience that specializes in solving challenges faced by enterprises when building a differentiated customer experience in an omni-channel environment. And lastly, we have Christine Riley. Christine is the chair of Manat's TCPA Compliance and Class Action Defense Group and regularly defends companies from claims brought under the TCPA, and she's definitely a prolific and frequent writer and speaker on the subject. And with that, we're going to dive into the agenda. We're going to do a quick company update just to give you a little context about us. We're going to dive right into the meat of the TCPA compliance updates, and then we're going to close out this hour webinar with a Q&A session. And with that, I am going to hand it over to Ryan Thurman, Contact Center Compliance.
Thanks, Alex. This is Ryan Thurman. I'm with Contact Center Compliance. We are proud to work with not only 5.9, but Innovista Law, and bring Manat to the table to talk about restructuring your compliance strategy post-ACA decision. Our company's been around for about 20 years, so we originally got our start back in the do not call era. Fast forward to 2018, and we're mostly dealing with TCPA issues, especially the rise of the professional litigator. And we're one of the few companies that's actually come up with a solution to identify these folks, both on an inbound and an outbound basis. We scrub about 30 billion phone numbers a month. We've never had a client fined, investigated, or had to pay out a litigator settlement as a result of using our software. We've got a pretty bulletproof solution, not only for TCPA, but also for do not call issues, and also for dealing with kind of right party contact and reassigned phone numbers that we'll talk a little bit more later in the slide deck. But we kind of look at things lately as it's just too dangerous out there to try to handle these things internally or on a one-off basis. There's a lot of complexity, and you need a trusted provider in order to have accurate data that's feeding into your dialer, so you can separate out manual campaigns and what's legal for predictive, and also weed out these professional litigators, because as Christine will explain a little bit later, things can go awry very quickly, and these settlements, especially when they're class actions, can turn into multi-million-dollar lawsuits. That being said, I'm going to go to the next slide, which kind of have some unique insight into the world of the litigators that are out there and really what their activity looks like. We're seeing about 50 cases a week filed just for TCPA, and the short story is there's no industry that's untouched for TCPA. Financial collections are obvious targets because a lot of times these litigators will bundle in FDCPA and FCRA claims, but you see even companies that are really in this B2B space facing TCPA litigators who have figured out that a lot of B2B companies don't do a lot of scrubbing and have neglected to look at TCPA as the statute being so broad that there's limited exemptions. So it's interesting to see some of the industries being impacted from TCPA, and we'll talk a little bit later in terms of a couple of case studies, especially in the solar and residential services markets, where we've been able to help clients both on the inbound and the outbound side in order to be compliant and run a automated solution that we've integrated with Five9. So that being said, I'm going to pass the deck over to Five9, and they're going to tell you a little bit about their solution. And Daryl?
Thanks, Ryan. Yeah, for those of you that aren't familiar with Five9, I wanted to give you a little bit of information about what we do. We are a cloud-based contact center provider. We're 100% in the cloud, meaning when we created the technology, it was designed to run in the cloud. And we're all about digitally transforming enterprises to move into the modern age of contact center and customer experience. Here's some of the stats that we're proud of here at Five9 in terms of reliability. We have a 12-month stat that we use on our trust site, and it shows 99995 reliability, which works out to be less than 27 minutes of downtime over the course of the year. So it's an extraordinarily reliable solution that you can move your contact center to with confidence. Over 3 billion customer interactions annually, and some other statistics here as well. In terms of the product, in terms of some of the capabilities that the platform supports, we support, next slide, Alex, thank you. We support all the channels that you would expect in terms of inbound voice and outbound voice. We'll talk a little bit more about that in just a second. We also support chat and email, and even pulling context off of the web if your customers are starting there, like many customers do, before reaching out to you on an inbound channel. In terms of the agents on the right-hand side, we support agents, all different types of agents. Because we're in the cloud, we have a completely thin service offering, meaning agents only need a laptop and an internet connection in order to use it. We handle the desktop. We integrate into CRMs like Salesforce and Zendesk and others. And the agents can take a look at that. They can log in over the web. They can see all of our tools, and we'll handle the information flow, the routing to the agents, and the voice traffic as well. In terms of outbound, to touch a little bit on that, we have a very powerful outbound dialer. Supports all of the different methods that you would expect in terms of predictive and power. We also support something called manual touch, and we actually created that to help comply with the TCPA legislation. And to talk a little bit more about that, quite a bit more about that, in terms of some of the changes that have happened recently in terms of the recent ruling with the D.C Circuit Court, I'm going to invite John Nelson and Christine M. Riley to talk about what's changed and what that might mean for your business. One thing to keep in mind, you'll probably have questions as we go through this material. So take a look at the question section on the right-hand side, and I'm going to ask everybody if you can find the questions, and you can hear my request. Go ahead and type in "I hear you" or "I'm here," and that way we'll know that you know how to use the system to ask questions. Cool. And with that, I'll ask John and Christine to go ahead and take it away and educate our audience.
Great. Thanks, Daryl. And we can go to the next slide. Well, it's been about a month and a half since the D.C. Circuit's decision in ACA International, and we're finally starting to see some movement from the courts and the FCC as both groups react to that court decision. So today, myself and Christine would like to briefly go over the reactions, emerging trends, and the practical implications of those TCPA issues addressed in that decision. We'd also like to touch on some non-ACA TCPA trends that we've been seeing in the courts, especially in regard to determining who is the sender of a call or message and the issue of vicarious liability. So with that, let's get started, and we can go to the next slide. So the first issue that the D.C. Circuit tackled in its opinion was whether the FCC's interpretation of the ATDS term was unreasonable. This is based on the 2015 TCPA order, which sought to define ATDS really by interpreting the word capacity that was in the ATDS definition in the statute itself. And the 2015 order defined capacity pretty broadly, actually really, really broadly, so that the ATDS definition also applied to devices that could be modified in the future to have the capability to generate random or sequential numbers. So for example, your smartphone via, say, an app or some other upgrade. And the DC Circuit really did not agree with this definition and found that Congress wouldn't have wanted the TCPA to be so expansive that it applied to the everyday consumer and their smartphone. So it struck down the 2015 order's ATDS interpretation. And you would think this would be a victory for businesses like yourself. But to be frank, we really don't know for sure if it's good or bad, because now there's no SEC guidance, at least from 2015, as to what is and is not an ATDS. And this lack of clarity has started to emerge as a really key issue. And we can go to the next slide. Now, I should note that since there is no SEC guidance on the ATDS definition, it is now up to the courts to decide what is and isn't an ATDS. And we believe that courts will interpret this term much more narrowly than the SEC did, and that they will start to only look at the device's present capacity, not its theoretical or future capacity. And that courts will also rely significantly on expert opinion in determining what a device's present capacity actually is. A great example of this actually comes from a Nevada case, Marshall versus the CBE group. Now, in that case, the federal judge was asked to determine whether the defendant had contacted the plaintiff using an ATDS. And the judge elected to base his decision off of the language provided in the TCPA statute itself and his interpretation of that language. In doing this, he determined that the statute itself was meant to only cover a device's present capacity, not its potential or future capacity. And once he had what he believed to be the proper definition in place, he looked to the facts and to the contrasting expert opinions that analyzed that device's functionality, and ultimately in that case decided that the device used was not an ATDS. So in the courts at least, it would appear that judges are defining an ATDS based off of the present capacity. But I should note this path of thinking is not set in stone because very few cases have been decided. And also, to throw a little bit of confusion into the mix, it looks like the FCC is going to readdress this issue again. Actually, last Thursday, ACA International, the U.S. Chamber of Commerce, and 16 other parties filed what's called a petition for declaratory ruling. And essentially what they've asked is for the court to open up a notice for public comment on the ATDS definition and issue a new interpretation that falls in line with the present capacity definition that courts have been using and that the D.C. Circuit mentioned in its decision. And I would be surprised if the FCC strayed too far away from what the petitioners have requested and what the courts kind of have been doing with the ATDS issue, especially with Chairman Pai at the helm. Again, though, all of this is not to say that the commission could come to a different conclusion. Now, I don't believe that the commission has released a public notice seeking comment on that petition just yet, but this is certainly something that businesses should monitor. And once that notice comes out, definitely something that they should think about submitting comments on, because too often industry leaders really fail to engage with the FCC in that decision-making process. And this can really affect the outcome of whatever the agency decides. So now I believe we have a poll question, and after that I will turn it over to Christine to talk about some practical implications of the ATDS issue.
All right, so everyone that's listening should see the quick poll that's on the screen. Have you made any changes to your dialing strategy based on the new ruling? And what that question basically means is, are you making changes or have you made changes to your system? For example, have you decided now to do predictive dialing when you weren't doing it before the ACA ruling? Have you decided to switch your platforms? Have you switched different telephony systems based on the ruling? So everyone, please go ahead and choose yes or no, and we'll see what the results are before we talk about implications. Ryan and Alex, are we able to see the polling results?
Not yet.
All right, so maybe we'll at least get started on implications and we can discuss the polling results when they come in. So this has been probably the hottest question since the ruling came out. The question has been, so now what? We've got a really favorable ruling from the D.C. Circuit that threw out a pretty expansive interpretation from the FCC, but now what? So that is sort of the multi-million-dollar question on ATDS. Now, John is absolutely right that there is now a lack of clarity, sort of a gap that's been created. Because while the FCC says that the FCC's interpretation is too broad, the D.C. Circuit didn't say really what the definition should be. Now, if you were expecting the D.C. Circuit to say that, that's probably not their job. Their job was just to look at, was the definition or the interpretation reasonable? So I think we're going to see something from the FCC, and maybe it'll be on the U.S. Chamber of Commerce petition. But in the meantime, your question is, what do we do now? Well, you might talk to a few different people, you might get a few different answers on this question. But given the lack of clarity in what courts will do, I think we're still pretty much at a status quo if you want to be conservative on your TCPA compliance. And what I mean by that is we're probably going to see some trends developing in the courts, just like we saw with the Marshall case. We saw the Marshall case say that it's going to be present capacity. At least that's the way that one court interpreted that capacity information. But that doesn't mean all the courts are going to agree that it's present capacity. I think a good amount of courts will probably go along those lines until and unless the FCC says something more. I see we now have our quick poll up, and it looks like there's a resounding no in response to that polling question. And I would say I think that is the right decision in the meantime. I think the things that you should be thinking about doing in light of this sort of in-between stage that we have is you should still maintain a pretty aggressive stance on autodialer. So that basically means if you're going to be calling mobile phones, make sure you have the appropriate consent. We're still, to this day, in fact, I had this conversation just yesterday, still having conversations about creating separation between, doing predictive dialing on landlines versus doing a manual type of dialing for mobile phones, and looking to separate those systems as much as possible. We're still having conversations since March about bolstering any kind of human intervention in your dialing system. Now, as you know, or you probably know, there has been some really great trends in the case law that talk about click to dial perhaps being enough human intervention to be outside the definition of autodialer. It's a great trend, not something that you can, bank on, but there is a good trend in that respect, and it will probably continue with the new ruling that came out from the D.C. Circuit. You should also be thinking about, if you are one of those companies that has made changes to your dialing platform and in a way that you believe is either more compliant or helpful, you should be maintaining documents and policies so that if there is some type of challenge to your practices, you have something on the ready to present to get that lawsuit resolved as soon as possible. And what I mean by that is I have seen cases where companies have been ready for the TCPA trolls that come out of the woodworks because you know they appear at some point. They file a TCPA claim and we're ready for them. We know that they're coming, but we know we've made some changes to the system and we know we've been very conscious on our TCPA compliance. And what we've been able to do is present a document, present a short layout of the dialing system to say, this is not an auto dialer for X, Y, and Z reasons. And it is often the case that if the systems are separate and you've got a compliance plan in place, you scare away the plaintiff lawyers who don't want to invest the time and money into fighting an auto dialer issue if there's not a big payout or return at the end of that. And one thing to always keep in mind is these plaintiff lawyers that file these lawsuits, they do not get paid unless there's either a settlement or a judgment in their favor. So all the time that they spend working could perhaps never come back to them and they can never be reimbursed or paid for that time. So that is why you want to spend as much effort as you can up front to get rid of those lawsuits and to persuade them that this is not a case that's worth investing their time and their money. You should also consider scrubbing for mobile phone numbers if you're unsure about the auto dialer assessment or if you don't have consent. Now, of course, if you do have the right consent under the TCPA, you know, you're in a great position because consent is golden. That is sort of the best thing that you can have, and then you don't have to focus on the auto dialer question. But if you're not sure if you have the right consent, or there's at least some instances where you may or may not have consent, you have to be thinking about the auto dialer assessment. So I think the message here is we've got a great ruling and we're moving in the right direction, but we are not out of the woods yet. I think we all expect that there's going to be some favorable decisions, just like in the Marshall case. I think we also expect that the FCC, under Chairman Pai's guidance, is going to come out with a definition that actually makes sense, or at least makes more sense than what the previous administration did. But until we really get there and until we get the clarity, you're best suited to keep on the current track, because I'll tell you this, the plaintiff lawyers, from their perspective, they see the D.C. Circuit ruling as a potential blow, but they are by no means stepping down from TCPA. And I'm going to give you an example of a conversation I had with one plaintiff lawyer. When the D.C. Circuit ruling came out, we asked one of the most prolific filers of TCPA lawsuits in the country, what's your take on this? Do you think your TCPA cases are now done? Are you not going to file these anymore? And the response we got was, you know, we know the D.C. Circuit ruling, we know what it says, but we're going to push the envelope on TCPA for as long as possible. And you know what? We're going to continue to argue about capacity all day long, because we think we can still convince courts that the statute is pretty expansive and consumers have the right not to be called or to be bothered. And we're going to continue to push the same arguments that we've been making before. So from our perspective, nothing has really changed. Maybe there's more of a question mark, but we're not changing what we're doing. So if that's not enough, hearing it from the plaintiff lawyers themselves, really stay to the current track. And you know, one of the things I think we can talk about later, if you have made changes to your system, we'd be really interested in hearing what kind of changes you have made. And if you want to provide some comments in the chat box, maybe we can take up some of those questions later. We can discuss some of those changes and how they fall on the risk scale in light of the D.C. Circuit ruling and where we currently stand. And I'm going to pass it back to John Nelson to talk about the reassigned number ruling.
Great. Thanks, Christine. So next is the reassigned numbers issue. And the D.C. Circuit tackled here the FCC's conclusion that callers would be liable for contacting a reassigned number without the new user's consent after only one call, which I'll refer to, and I'm sure you've heard many times, is referred to as the one-call safe harbor provision. And the court overturned this one-call safe harbor because the commission, itself had acknowledged in its filing actually to the D.C. Circuit that there was no present solution for determining whether a number had been reassigned, and that the new user didn't even have to inform the caller that they were new to that number. Now, because the court overturned the commission here, the FCC has now been given another chance to get this right. And actually, this is one of the areas where the commission has been in the process of trying to right its wrong, really both before and now after the D.C. Circuit's opinion was released. Certainly, like I mentioned, this has been an attention-grabbing issue for the PI Commission. And the best example of this really is the Commission's further notice of proposed rulemaking on reassigned numbers, which was actually adopted right after the ACA decision was released and published in the Federal Register about a month later. So specifically, this notice has requested public comment to ensure that one or more databases are available to provide callers with comprehensive and timely information regarding numbers that have been reassigned. And also, and this is really important, what type of safe harbor should be provided to callers who subscribe to any FCC-approved databases. Now, as of right now, and in that notice, it appears that the Commission is going to choose from either a single FCC-designated database or multiple commercial databases that are FCC-approved. And it also appears that the Commission is going to decide whether service providers will be mandated to report reassigned numbers or rather have them report those numbers on a voluntary basis. So like I mentioned, this notice is currently out for public comment, and comments are due June 7th. And again, I would encourage you to engage in this process if you have not already done so. And also I should mention, and I think this is key, in the interim, I would recommend, and I'm sure Christine will expand upon this idea, that you implement some sort of reassigned numbers scrubbing system, because given the DC Circuit ruling, there is now actually no safe harbor provision, which means you don't even get that one call to a reassigned number before TCPA liability kicks in. Now, obviously, hopefully, a new safe harbor is implemented along with some sort of nationwide database structure, but the Commission will take a while to actually implement such a rule. So in the meantime, businesses need to really rely on the commercial databases that are currently available and immediately place any reassigned number on an internal do not call list. So I think we have another poll question, and then again, I'll turn it over to Christine.
Yeah, this is Ryan. We've got a poll really just about the reassigned number issue in terms of level of risk. We've seen some companies kind of taking a wait and see approach, others kind of diving in head first with a reassigned solution, and given that the fact that the safe harbor is kind of eroded with the DC Circuit. So the big thing with running reassigned phone numbers is that it kind of varies in terms of like the quantity of reassigned phone numbers you might have based on a few factors: the age of your data, how well you clean it and keep it updated, the industry you're in. You see a much higher population of reassigned phone numbers, especially in collections, or younger demographics play into it. It also depends on your last contact date. If you only touch your customers a couple times a year, you might not be able to have a right party contact date that's relevant. And the main thing that's really, I think, been slightly good for the industry is that the way reassigned scrubbing is now compared to what it was when it first came out as a kind of a requirement is that the cost has come down, the accuracy is much better. So we have a lot better visibility, and especially into some of the lower tiered markets, into data where it's coming in, we have partial information where we can match 98, 99% of a file. But overall, you do see sometimes upwards of a 20% of a database that actually is reassigned when it comes to cell phones, which, you know, you got people like Melody Stoops, who she keeps a shoebox full of reassigned phone numbers underneath her desk to basically wait for your phone calls and get a wrong party call and use it to fund her vacations. You can read about her in Forbes. She's quite obvious about how she procures those. I'm going to close the poll and then share the results, and they kind of a split between moderate risk and I have no clue. We can help you with the no clue. We can run a sample analysis for you on reassigned phone numbers to give you a guesstimate based on, you know, a sample size of a couple thousand records of where that might sit. Christine, did you want to have anything add on the reassigned issue in terms of like what your clients are doing about this now and their reaction to the D.C. Circuit?
Sure. You know, I think we still all face some potential liability for reassigned telephone numbers. And this is another instance where, you know, keeping to the same compliance strategy and trying to reduce contact, outbound telephone contact to reassigned telephone numbers is the way to go. I think this is, you know, the fact that we no longer have a one-call safe harbor and now we're left with no definition, in my view, hasn't really changed very much. Because let's face it, the one-call free pass that the FCC gave us wasn't very useful to begin with. One call that meant anything, even if you called and you just received a voicemail with no name, that was considered your one call. We didn't find during the time that we had this one call safe harbor, we did not find that it was helpful in any respect. So I feel like we're probably really sort of where we were before, except the FCC's safe harbor and perhaps their interpretation is off the table now. I think we're going to be getting clarity on this issue, and the FCC is closing in on that with coming up with some type of database. But it's going to take a while, like John said. It's going to take a while to get there. I think we are going to have pretty clear rules on scrubbing for reassigned telephone numbers sometime when the FCC finally puts it all together. But you're probably looking not in 2018, you're probably looking sometime in 2019. The FCC, as we know, does not move particularly fast. So in the meantime, keeping to the same strategy plan of reducing contact to reassigned numbers is the way to go. And some suggestions that can help do that. Obviously, contact center compliance has a reassigned telephone number solution that works very well. So you can always take your list and you can have them scrubbed by Ryan. He can tell you, you know, this is how many reassigned telephone numbers we're seeing in your calling list. And in fact, doing that kind of scrub will give you an idea of what kind of risk you have. And as you see, some of you, or a large majority of you, don't seem to have a good idea of what that risk is. So I would encourage you to talk to Ryan so you can at least get a better sense of what that risk looks like while we have this interim period. Now, if you're trying to reduce risk on this level, in addition to getting scrubs, you can also prepare your customer service agents to identify and report reassigned telephone numbers. That means you've got to have some systems in place that when someone says that, you know, it's not me, you're calling the wrong person, that you update those and you maintain records of not calling that number anymore. Or even if you can flag questionable accounts where you haven't spoken to someone in a long time, instead of using your autodialer or predictive dialing to call those numbers, you might manually call those numbers until you get clarification of who is the subscriber. There's also some technology that recognizes triple tones and disconnects, which will give you a signal that the number is no longer in service. If you have an IVR as part of your compliance measures and you send pre-recorded voice messages, Having an opt-out for wrong numbers or just general opt-outs is preferred and is recommended. If you're doing text messages, you might consider putting stop instructions on every few messages or even every message that's sent, so that the new subscriber has an opportunity to opt out of those messages. Though of course we know they don't always do that. And any other ways that you communicate with your clients or your customers is a way to confirm you've got the right subscriber, the same subscriber that gave you consent in the first place. So for example, if you have a company where you have your consumers logging into accounts online, you might consider having a prompt when they log in, asking them to confirm their current contact information, or even asking them for their current phone numbers and having them add those in. You could do that upon login. I know I have some accounts that when I do log in, I do get those reminders, and it comes up before I can even access my account. So any opportunity you have, whether you're making a call out or a customer is calling you, or they're logging in or communicating with you, is an opportunity to confirm that you have the right subscriber. And again, these are measures I think that we still need to take until we can get the FCC's database solution in effect. But it's going to take some time, and it's not likely to happen in 2018.
Is the danger with the reassigned numbers the fact that most of these come in the form of class actions?
That's actually an excellent question, Ryan. You know, a lot of the time, the reassigned telephone numbers tend not to be class action cases, though there are some. The cases we see where reassigned telephone numbers tends to be a class is where there are records in the company that very clearly have a disposition that say wrong number or, you know, wrong party or something of that nature. That's like a gold mine to a plaintiff lawyer. And I have clients that, you know, you make calls and you have different disposition codes, answering machine, voicemail, not interested, wrong number. That's from a TCPA defense counsel perspective, it's frightening to see, because I immediately think, well, gee, if a plaintiff's counsel ever sees that disposition code, they've now going to point to that as their way of defining a reassigned or wrong number class. So that's where we tend to see that issue, and we do everything possible not to provide that kind of code. I've had some cases where we've had to sidestep that and be very careful about the information we provide the plaintiff's counsel. But that's where we tend to see it. A lot of times it ends up being an individual issue where you can argue that, yes, maybe we call the wrong person here, but we'll just figure out a way to make your individual plaintiff whole, but we will not settle this on a class basis. So if someone really got a new phone number and they were called a couple of times, those cases will often resolve because it's not worth the time to litigate them. You can probably pay a nominal settlement and everybody can move on and get back to business. And John, I'm sure you might have your own experiences, but those have been my experiences on the reassigned telephone number so far.
Yeah, I would definitely agree with you there. And kind of just to keep going here, I think I'll move to the third issue coming out of that ACA opinion, revocation of consent and the reasonableness standard created by the FCC. So the D.C. Circuit addressed the FCC's conclusion that a consumer who provided consent must be allowed to revoke that consent, and that a caller must accept all revocations that are made in, and I quote, any reasonable manner. Surprisingly, the court chose to affirm the FCC's reasonableness standard, even though it isn't really clear what is and is not a reasonable opt-out method. And by making this decision, the D.C. Circuit essentially signaled to lower courts that they would be tasked with mapping out this reasonableness spectrum. So now we're kind of in a holding pattern waiting to see how courts will define what is and is not a reasonable opt-out method, of course, off of current cases and those in the past. And unfortunately, I think this creates another murky area for businesses who are trying to be TCPA compliant. And I think it will likely take, again, some time and probably, unfortunately, some lost cases before we really have guidance on what is and is not reasonable opt-out. You know, thankfully, though, we're already starting to see some decisions come out in this area of the law. This is really something the courts have done for a while. Defining reasonableness is something they're definitely used to. And it appears that, at least in the text messaging context, judges are starting to get fed up, you know, with those crafty plaintiffs who are consciously avoiding easy opt-out methods, like texting the word stop, and, you know, instead using more crafty methods of revocation, like texting back full sentences. We've even seen a case where someone responded in poetry in an attempt to opt out. So I think the cases, the two cases really, Rando versus edible arrangements and Franklin versus express text, are both great examples showing the emergence of this trend. In both of those cases, the plaintiffs sued for text messages that they had received after responding to a text campaign with basically phrases other than stop, cancel, unsubscribe. They would respond with, hi, take my contact info off, please. I want to stop the service, thank you. And in both cases, the respective courts reasoned that, you know, even though the plaintiffs were nice in their request to opt out, their responses weren't reasonable opt-out methods, because in each, the plaintiff had failed to abide by the texted instruction they had received, explicitly asking them to just reply stop to cancel their subscription. So at least in the text message context, it appears that the courts are already starting to create a spectrum for callers to follow. Again, though, I cannot emphasize enough how you know, little time has gone by since the court has started to fully analyze this after the ACA international decision. But you know, hopefully we will continue to monitor this and see how it evolves. So again, I'll pass it over to Christine.
Can I get an amen for those cases with poetry and crafty, imaginative responses that are now being rejected? I mean, it's about time. I'm so tired of seeing these ridiculous lawsuits that are filed that take up our clients' time and their money, and they're just ridiculous. They're ridiculous, and they're just efforts that are trying to manufacture a TCPA claim where clearly there is no TCPA claim. So this trend is a good one. Even the D.C. Circuit said, listen, if the consumers are not clearly rejecting, you know, that they don't want to be contacted, and they're avoiding simple opt-out instructions in favor of these really imaginative opt-out attempts, that's not going to fly. That doesn't make any sense. But I think where we go back to is the standard that the FCC came up with is one that looks at a bunch of factors, but I'm not terribly surprised that the D.C. Circuit stuck with this. Basically, you're looking at a standard about what's reasonable. And that's not unlike a lot of standards in the law, whether something's reasonable. So you're going to have to look at whether the consumers have clearly expressed, that's key, clearly expressed a desire not to be called. You have to look at what the reasonable expectation is of communicating a request to stop in that circumstance. And also, and this is really what's favorable, and we've been saying this since the moment this ruling came out, the revocation request should not produce an undue burden on the company. That's something that seems to be lost often, but it is a really good argument for companies when you get these types of claims that they revoked consent and it wasn't honored. So what do you need to do from here? Well, like John was saying, you do need to be vigilant about having revocation processes in place. You have to have a way of honoring and accepting revocation. You should be looking at your scripts. You should be having options on your IVR. And here's a really big one. And listen up, everyone, because this one is really important. There was discussion in the D.C. Circuit ruling about where a company provides opt-out mechanisms in their terms and conditions. And the D.C. Circuit said the contractual provisions that provide specific opt-out mechanisms were not prohibited by the FCC's order. Translation, it means if you are going to provide the means and method to revoke consent, put them in your terms and conditions and dictate what is reasonable for that consumer. So if you're a company that has online terms and conditions, you have contractual agreements, put language in there specifying how that consumer should opt out. You say, here's our email where we accept opt-out requests. Here's a phone number where we accept it. Or you give instructions on how to opt out of text messages. Or you do all three. The point is that there is an ability here for you to take some control on how you accept the revocation. So if you have a specific and a reasonable policy in place on how to accept revocations, if a consumer decides not to follow them, you have a good argument to say that their request to revoke consent was not reasonable because they avoided and they refused to honor what was in the agreement with your company. And that's huge because a lot of companies do have these terms and conditions, and we lawyers spend a lot of time putting in provisions in there that we want to enforce. And we're basically getting as close to a green light on that as we can get. So I would encourage you, if you haven't already done so, have a TCPA provision, a telephonic communications provision in your terms and conditions or in your contract. And let's try to minimize the risk on revocation of consent. You're still going to be stuck with a reasonable expectation standard. So let's do what we can in order to have it be more favorable to companies and put clear provisions on how to do that you know your company is able to do. So I think that is a really good result from the D.C. Circuit ruling. And I know we've been spending a good amount of time revising terms and conditions and putting together robust TCPA provisions for this very purpose. So continue to be vigilant and consider making some changes to your contracts and terms and conditions if you've not already done so.
Great. Thanks, Christine. And I would like to echo that as well. You know, we've been doing that a lot recently too, really looking at those terms and conditions. People don't read them, but they really can be a saving grace, especially within the TCPA. So that is what is going on in the post-ACA world. And I guess given the time remaining, I'll ask Ryan and Alexa real quick if they want me and Christine to go into the non-ACA trends, or if we should maybe get into some questions and the rest of the content.
Ryan?
It would help if I unmute myself.
There we go. Now we can hear you.
I would say let's go forward with the ACA trends. And then to your last point about contracts with consumers, I know the CFPB had some issues with arbitration clauses and requiring those as far as TCPA complaints. Is that still a good best practice to put those in customer agreements? And I'll leave you guys to kind of chime in on that.
Yeah, the CFPB is its own sort of beast altogether, and they have repeatedly taken the position that mandatory arbitration and class action waivers should not be enforced. But I can tell you this: as far as we're concerned, I mean, while that works itself out on the CFPB side, we continue to put those provisions in, and why we put them in because it's often the case that courts will allow us to compel arbitration. And if we can compel arbitration, we can basically defeat a lot of these class actions. Because once they go to arbitration, it seems that the plaintiff's lawyer typically loses interest and there's no class to be discussed. It's really just an individual case. Now, with this all evolving, it could be the case that some courts will find that your provisions and your terms and conditions, such as class action waivers or mandatory arbitration, are not enforceable. But you're going to have some courts that are going to enforce them, unless we have, a law that specifically says that you cannot, under any circumstances, allow those provisions to be enforced. But that's still a growing area, and it's still a issue that is controversial, that we do see success on. And as a matter of practice, we do encourage putting those provisions in there and trying to enforce them whenever possible.
Maybe we can shift gears back into the non-ACA trends. I know, Christine, we were talking earlier, you had some interesting commentary and a strange coincidence on this first case here that maybe you can shed some light on, that are things that are going on currently and some of the major cases that are out there.
Sure, happy to. And I think I'm going to actually toss it back to John just to set up the scene, and then I can kind of tell you where things are at.
Sure. So in this non-ACA world, we are still obviously seeing other trends growing. And two specifically are determining who the sender of a message is and the issue of vicarious liability. Now, in our own experience, we've seen the who is the sender issue come up quite frequently. And as an example, I'll give you the details from a California case where a Buffalo Wild Wings customer had given his phone number to the restaurant hostess to notify him when his table was ready. The hostess then inputted the customer's number into a platform that was hosted by Yelp, in which, because of the hostess's action, sent the customer a text inviting him to download one of Yelp's apps to keep him apprised of his wait time. So no surprise, the customer brought suit and against both Yelp and Buffalo Wild Wings. But really, there's a unique issue here, or I guess not so unique. Who is the sender? Are they both the sender, or is just one of them the sender for TCPA purposes? Well, the court in that case has taken what is now, at least what I believe, a common approach. And that is that the sender is the person or entity deciding whether, when, and who gets the text message. Now, in the case I mentioned, the court determined that that was the restaurant hostess, and thus Buffalo Wild Wings, because she had put his number in the application and decided whether and when that text should be sent to the customer. In the court's opinion, the Yelp platform had only texted the customer because the hostess told it to. So the key point to take away here is that companies need to design consumer-based apps so that it's clear who is taking ownership as the sender or maker of the call or text. If the user decides whether, when, and who gets the message via the app, then the user will probably be deemed the sender. But if the app hijacks the user's contact list, which we've seen a lot, so that random invite messages are sent to those contacts, probably the app developer will be deemed the sender. And then I'll quickly just mention vicarious liability before tossing it back to Christine. This is something that can typically be lost in the TCPA world, but is something that's really important. And I'll spare you the boring legal jargon, but essentially what brands and callers need to remember is that they don't have to have their finger on the send button to be liable. As an example, Dish was hit with major TCPA penalties for letting its agents run amok. And we saw an alarm company that was forced to continue in litigation because a third-party retailer had claimed, with that company's knowledge, to be selling the company's systems on the company's behalf. To be fair, there are some courts, like the 4th and the 9th Circuits, that have limited the extent to which a party can be held vicariously liable for the TCPA violations of another. And this is especially where, that third party is really acting on its own accord, or where the upstream manufacturer or principal is reasonably unaware of what that third party is doing. And also where there's an agreement between the manufacturer and that third party requiring the third party to comply with the TCPA. So the take home here is that any party engaging a third party services to sell or market goods really needs to be cognizant that that third party is complying with the TCPA. And the best way to do this, in my opinion, really is through contract with that third party and through proper TCPA compliance training. So with that, I'll toss it back to Christine.
Just a quick comment on the Meeks versus Buffalo Wild Wings case. It is a case that we represent one of the defendants. So there's very, very little that I can say about that case or comment on, since it is current litigation. But that case is on appeal before the 9th Circuit. They just filed an appeal notice. And so it is a matter of to be continued. One thing I can share about the case is, while Yelp was dismissed, the remaining defendants moved to transfer venue, and we were successful in doing that. We had the case moved over to Los Angeles because we thought the judge in the Northern District was not going to give our client a fair shake. And that became very obvious at the hearing on the motions. So we were successful in getting to Los Angeles to have a new judge. We drew Judge Anderson, who is a tough judge, but Judge Anderson granted our motions to dismiss on the basis of the autodialer question. We argued that the kinds of messages in the communications with the restaurants of providing the phone number and then getting a response text message could not have been an autodialer. And Judge Anderson agreed on the pleadings and said the pleadings did not sufficiently allege an autodialer, and he dismissed the remaining defendants in the lawsuit. Or rather, he granted the motions to dismiss, and then the plaintiffs decided to just dismiss their entire case and then file for an appeal. So there's another autodialer aspect to that case that you might be interested in. And in the meantime, on the vicarious liability, it is very much a to be continued. And I see we're getting towards the top of the hour, and maybe we can just talk about a couple of takeaways and take some questions. That works for everyone?
I think that's a good idea.
Yeah, let's do it.
Okay, so real quick, I guess, I think we'll just go over some, things that we've discussed that can apply really to every business. Number one, and I've mentioned this several times, your businesses really should participate in the notice and comment rulemaking processes that the FCC opens. They have on several occasions really referenced that, they hear a lot from the consumers and how aggravated they are about telemarketing calls, but they don't hear as much as they need to from the industry, and really how we can advocate and implement pro-industry guidelines and standards that still at the same time protect the consumer. Also, in the interim, while that's ongoing, your business should actively use a reassigned number database and or a scrubbing tool that is commercially available, so as to limit your TCPA risk until these new rules come out. And then finally, on those non-ACA trends, if your business runs an app or a service that is fairly user interactive and allows that user of the app to text others, make sure it is designed in such a way that it's clear whether or not you or the user are the sender. And then to evade vicarious liability suits, enter into contracts with your third-party agents and reps in which they acknowledge to comply with the TCPA, and offer TCPA compliance training to any salespeople you may have.
Well, we're 2 minutes over. I know we had promised a little bit of Q&A. Maybe there's a couple of key questions that we can answer. I think it's worth saying, this is Daryl Addington from 5.9, that the 5.9 solution works with the contact center compliance solution quite well, and unfortunately we didn't get a chance to really dig into it today, Ryan. But if you are looking for outbound solutions that are going to be more likely to comply with the TCPA, combination of 5.9 and the contact center compliance solutions is potentially a great fit for you. So you can check into that. What kind of questions do we have that we can answer? Maybe just one or two that look like they're really relevant for the audience.
I think the one that just got submitted was actually kind of looking forward, what are the further thoughts on the recent petition, the timing, the outcome of some of these events. I think what we saw from the poll was that, a limited amount of people made any substantive changes to the way they're dialing. So, with technology being something you almost need a longer curve to get things right-sized, any idea of what people can expect or ways that they can tune into this stuff to keep track of it a little better, to see when they might want to make changes or what they need to wait for?
You want to direct that? Great.
I was going to say that John and I, we at our respective firms, both issue updates on a regular basis. I know our firm has a TCPA Connect newsletter, so anytime we get any significant updates, we send them out either as a special alert or as part of our monthly newsletter. And I think John can speak to what his firm does as well. But I think another thing that you can do is, contact center compliance is very much on top of this stuff and usually ahead of the curve in terms of what's going on in TCPA in the industry. So to the extent that there are some major changes and updates, you'll probably hear from Ryan as well. They'll send out either an update on their newsletter or also do some type of webinar like we're doing today.
And I guess just to add to that, we at the TCP Defense Force, along with several other firms, have a pretty active blog, which we update very frequently with important cases that come about, or administrative filings, comments. As an example, when that Chamber of Commerce petition regarding the ATDS issue came about, we had that up online on our website the day after that they had filed it. So we really do try and do our best to keep up on that issue. And I'm sure if you go to ours or Christine's respective website, you could sign up to receive that newsletter. You can sign up to receive updates about our blog posts when they come out. And really that is one of the best ways to stay up to date, because we do care about this issue. We understand how important it is for all of you, and we want to give you, that important information as quickly as possible.
One other thing I want to mention is what we have done is we created a TCPA Defense Forum on LinkedIn, and it's a forum in which folks from different industries, in-house counsel, company representatives, different law firms, including Manat, who hosts it, as well as other law firms, post information about TCPA. And it is an invite-only type of forum. In fact, you can't even find it if you were to search on LinkedIn. But if you would like some access to that forum and that group, just send me an email and I will get you in that forum. And one of the things we do in addition to updating is occasionally we have questions and just brainstorming from a defense perspective on what we can do on different TCPA issues, including making contacts, referring experts, all sorts of things of that nature. So if that is of interest as well, you can always reach out and I can get you in a defense forum. And again, it's on LinkedIn, so it's only for defense side. We do not allow any plaintiffs, any plaintiff lawyers, and we vet every single person we allow into that discussion group.
I think those are good resources. The other thing that I would throw out there is that we have a joint, or a 5-9 has a CX Summit next week down in La Jolla. I think they're pretty full as registration, but Contact Center Compliance will be down there as well, so stop by and we can continue the conversation around how we can help you on the 5-9 system or any other system that we can plug into like 5-9. We also plug in the Salesforce, other CRMs, have open APIs, other ways we can integrate and try to simplify some of this stuff. We'll definitely follow up with answers to a lot of the questions that we just kind of ran a little bit short on time with. We'll also get some links out to the blog sites that you can kind of follow this information. We put out some newsletters and such, so got a couple different ways we can kind of give you some resources. And again, the Chicago Summit in July, we've got Innovista and Manat, both Christine and Joe Bowser speaking. That's July 10th out in Chicago. So good way to kind of spend the day with us. We also got the FTC, the Assistant Director from the Midwest, coming to speak. So it's a good way to kind of hear what their agenda is, because they've kind of been a little bit off the radar, but they've got some things they're looking at with call blocking and robocalls that are ramping up. And I think kind of running short on time, so I don't want to keep going over. Definitely get some resources out to folks. Christine or David, do you guys, or John, sorry, do you guys have any kind of closing comments for folks? And
I'll pass it off to Christine.
I think the one thing I'd leave with is, everyone continue what you're doing. Continue participating in these webinars, keeping yourselves updated, and we're going to do our very best to provide as much guidance and practical guidance as we can, knowing that there are some gaps here and there's some lack of clarity in the law. But if you have any questions, please feel free to reach out to anyone on the panel. We'd be happy to answer any questions you might have.
I think the general consensus is the more people that are on the practitioner side of the industry can work together and share best practices, share litigators and ways to kind of avoid these people, the more they're going to go after the people that are launching robocalls and spoofing caller ID. They're just the ones that really should be targeted for TCPA and other DNC issues. I think most people that try to come to our webinars and our summits, they're trying to do the right thing, but it's very easy to get roped into one of these situations and frankly be baited on the call where, a litigator or someone who works for a litigator is completely falsifying their information in order to get you to call them, text them. So it's just one of those situations where I think most people are trying to ride this out as long as they can, but definitely good to hear Christine's side of things, especially on some of the cases. And John, I really appreciate your insight and being able to put all this information. I think there are some good takeaways, and we'll definitely get out the slide deck, the recording, the links to some of the resources the next couple of days. So look for that in your email.
And on behalf of 5-9, I'd like to thank everybody on the call today. Really great information. Thanks so much for taking the time to share it with everybody.
Appreciate you joining us, Daryl, and definitely look forward to meeting some of the 5-9 folks down in La Jolla next week.
Yep, that'll be great.
So we're going to wrap things up, but we will definitely get back to some of these questions. There's some ones in here that I think we just basically need to take offline. As I'd imagine, you kind of open up the TCPA can of worms and gets very interesting very quickly. So appreciate everything from Alex and I over at Contact Center Compliance, Christine, John, and Daryl. Have a great afternoon.
Thank you.
Thanks, everybody.